person doing international law, so I really enjoy my collaboration with Professor Xu because Professor Xu's expertise is Chinese domestic law. So also thank you very much for the CSC conference funding. So the first time I presented this topic is in Singapore, and I received a lot of feedback, and then I further updated, finalized my paper. So my paper is applicable law to transnational personal data, and I will try to answer the questions Stone proposed just now. Here I compare 3 jurisdictions, China of course, EU, European Union as a jurisdiction, and then United States. And I try to find out what's the trends and dynamics in terms of applicable law for transnational personal data. So my conclusions are there are 4 trends. Okay. So the first one is multifaceted right to protect personal data. And the second is spread out unilateral applicable law approach. And the third is fragmented harmonization of substantive law. And the last one is the movement from de-Americanization, or from Americanization to de-Americanization of data industry regulation. And at the end, I'm going to discuss the dynamics among the 4 trends. So the first one is why personal data is transnational. So actually, Stone already gave us a typical example. Let the personal data can move from one jurisdiction to the other. So again, because we use the mobile phone, for example, if you have WeChat in your mobile phone, and the WeChat is a Chinese company, or if you travel abroad, for example, you go like Olivia, went with students to Shanghai, and possibly your personal information will be left there. For example, you use your credit card. So because we are movable, because the internet, the social website or internet companies, they essentially provide a global service. Therefore, consequently, our data come across the border. So the first trend is multifaceted right to protect personal data. So the question is, what's the legal nature of the right to personal data if it exists? Okay, if it exists. So my research demonstrates the 3 jurisdictions actually have very different idea about what's the legal nature. So the first one is the right to personal data a human right? And the answer is yes. If you talk with European colleagues, they are always very enthusiastic about the protection to personal data as a fundamental human right. Why? Because there are 2 very important European human rights conventions concluded after World War II. So one is European Convention of the Human Rights, and the second is the European Charter of Human Rights, especially the Charter of Human Rights explicitly extend the right to privacy and to the right to personal data. So how about the United States? So US is not a member state of the above mentioned 2 human rights conventions. But in the United States, the right to privacy is a right protected as a fundamental human right under the constitutions of the United States. US, very important, is the First Amendment, as well as the 14th Amendment, which protect the freedom of speech. So what's the relationship between freedom of speech and right to privacy under the US Constitution, or on the other hand, is right to personal data? So the first takeaway message is the right to privacy is closely related to right to personal data. And the second is, the First Amendment essentially is to provide the natural persons citizens, they can frequently express their opinion against government agency. But in the data protection, we always, most of scenarios is about a big multinational company which release your data without your consent. So the debate nowadays in the United States is to what extent the First Amendment, freedom of the speech, actually can protect ordinary consumers against a giant company like Facebook. So there are some implications from the First Amendment, but actually we should consider the implication is limited because the freedom of speech, the legal contact is against government. So how about China? So China actually, last Thursday, and I was in Fudan, I presented in a workshop organized by Professor Xu. So I actually asked my colleagues in Fudan, and not only Professor Xu, there's a lot of colleagues there, do you think the right to personal data is a human right in China? If it is, okay, if there is a right to personal data, is it a human right in China? So let me talk about my conclusion, maybe my bias, and then I move to what my colleagues in China tell me. So my conclusion is actually it's not. So why it is not? I have two arguments. And the first one is actually, some colleagues here already asked, how about Chinese government? So there are a lot of English literature talking about Chinese government is the biggest data collector in China. Initially, I think it is true because, if you are in China, you have to provide your personal data. For example, you pay, you go to a supermarket, so they may request you to use facial recognition or use your mobile phone or whatever, okay? Sometimes it's so difficult to even buy a coffee by cash, using cash in China. But with the second thought is, what do we mean by the government? I think this is another issue that China has to deal with in international law. Because outside of the China, we consider the state-owned enterprise is a part of the government. And the local government and the central government, they are all government in China. But I think, with discussion with Professor Xu, and I think it might be unfair to criticize Chinese government to connect too much personal data. Why? Because the data connected by the local government may not be efficiently and effectively shared with the central government. And also the data connected by the state-owned enterprise may not, freely shared with the central government. But the question, I think, for China today is, there is no effective protection of the right to personal data under the Constitution and under the data security law, and even, under a document that my colleague in Fudan suggests me to read. Okay. So this document is, in this year, China is the legislator, the NPC, National People's Congress, is working on a civil code. So the third chapter of the civil code is about the personality right. So last week, my colleague suggested me to look at the draft because they told me that the final version will be very similar as the third draft published August, okay, several months ago. So I look at the draft. So this draft says, Article 811 is that every natural person enjoying the right to privacy, 自然能享有隐私权. And then Article 813 said, the personal information of a natural person should be protected. 自然人的个人信息受法律保护. It does not talk about the right to personal information. So this is a very significantly different from US law and European Union law, because they explicitly talk about you are the natural person, so you have the right to personal data. But here, the Chinese language 是自然人的个人信息受法律保护，但是自然人享有隐私权。So the question is, what are the difference between the right to privacy and here your personal data? Because it is not a right, it's just your personal data. So the first is, I look at the Constitution. Last week I presented in Fudan. When I talk about Constitution, I think they are very surprised when you talk about Chinese Constitution, right? Because it's really different from, in US you talk about US Constitution. That's the big thing, okay? If you look at the Chinese Constitution, there are two provisions, may be extended to personal data. So the first one is privacy, and the second one is under criminal law, that your house and your correspondence should not be illegally accessed by Chinese government agencies, except for national security or criminal law investigation. So again, what are the differences between privacy and personal data? So from my reading of Chinese literatures, I think the majority opinion in China is privacy is not equal to personal data. So why it is not equal to? There are three arguments proposed by Chinese literature. So the first one is the meaning of privacy is to be alone, But the personal data, you need to use it. If you do not use it, you leave it alone. It doesn't generate any economic benefits or protect national security. Okay? And the second argument is privacy is to one individual, for me, for you, one person. But the personal data actually require a group of individuals, right? Personal data, the big data, you need to collect information from a larger group of people, and then you anonymize it, and then you analyze it. If you only have the data of one person, it's not useful. And the third argument that my Chinese colleagues, give me is state. State only act as a protector for individual privacy. They protect. They have no interest to know your privacy information, except for very limited, like national security or criminal investigation. But in terms of personal data, China as a state, they have interest. So for example, just now Professor Xu also mentioned to develop the knowledge-based industry, right? For example, to develop the 5G, etc. So they need the personal data. So, from this argument, and I think, go back, whether it is a human right, I think it is not a human right. But my Chinese colleagues tell me, last week, you should consider it is a human right. Why? Because it derived from right to privacy. But it does not convince me, okay? I think it is not protected as a human right. And the second is consumer right. In European Union, they think right to personal data is a human right. The consumer right, in terms of hierarchy, is lower. But in both China and United States, right, personal data are certainly protected by human right, by consumer right. For example, Chinese consumer law provided the three principles to use personal data: proportionate, necessary, and lawful. Okay. But regarding consumer rights, I just want to add the question about the consent that Professor Xu answered. And I fully agreed. My understanding of the issue of the consent in China is, what do you mean by consent? So for example, very recently there is a case in Hangzhou there is a safari park, animal safari park in Hangzhou, which require every consumers, you need to do the facial regulation. If you do not provide the features of your face, you are not allowed to go into, you just not be able to go into the park. So the question is proportionate. So if you allowed a business like a safari park can freely to collect consumers' facial, features, because the facial features are different from your fingerprints. Fingerprints you can put in your pocket and nobody knows, but your face are exposed. I think that's an issue in China nowadays with the technology development. The business, the companies, they can freely offer service to consumers. If you like to use my service, you must consent, right? In the case of the safari park, if you like to go to the safari park, you must consent. Otherwise, you take it or leave it. So that case was currently brought by a professor in China into a Chinese court, but just let's see how to deal with the issue. Another issue regarding consent is, also very recent. So next time if you go to Beijing, you take a metro. Now the Beijing metro system is moved to facial recognition. So means that if you like to use the metro, you possibly need to provide you some personal data as an exchange. So the argument for this update is it's more efficient, right? In the rush hours, the thousands of people want to use metro. It's more efficient. You just scan your face and you come in. But again, the issue is it appropriate? Is it necessary? Okay. So I think this is the big issue for consent in terms of consumer right. And the last one is property right. In EU, certainly it is not a property right. But in US, some scholars, even a case decided by US Supreme Court held that it is a property right. This idea also gets support by some Chinese scholars. I probably have no time to go into detail. Now let's quickly move to the second trend, which is the spread out unilateral applicable law approach. Again, move to Storm's question, which law should be applied in the situation where a Chinese company offers service to Australian consumers which unavoidably collect some data? So the answer is it depends on which court and which regulator you go. If you go to Australia, for example, ACCC, they certainly apply Australian law. If you go to a Chinese court, a Chinese regulator, for example, State Administration of Cybersecurity or whatever, Chinese administrator, they will apply Chinese law. So the question, the spread out unilateral applicable law approach, which law should be applied, it depends on which court and which legislator you go, okay? So we call it mandatory law. And the second is curtailing party autonomy. So suppose that you are a customer of WeChat and you need to click yes to the user's agreement. So further suppose that the user's agreement, and I would say this is not an assumption, it is true, the WeChat user's agreement said Chinese law should be applied, and the issue probably will be resolved in a court in Guangdong or Shenzhen, okay, a Chinese court. Now the question is, this is called the party autonomy. And the question is whether parties are allowed to select a law which provide lower personal information protection. So for example, if I'm a consumer in European Union, this is an extreme example because in European Union, the GDPR, the General Data Protection Regulation, provides very high protection compared with Chinese law. And let the consumer click yes, okay. So the question is whether parties can freely opt out of, can freely select a law provide lower protection. The answer is no in Australia. So our privacy principle explicitly provides parties are not allowed to freely select a law which provides a lower protection in terms of consumer privacy compared with Australian law. So how about the Chinese situation? So generally, Chinese law does not have such a requirement, but also very recently, Chinese legislature has a special regulation for minors. Minors means less than 18 years old, okay, minors, personal information of the minors. And the regulation indicates if the internet operator would like to move across border, move outside, move the minors' information connected inside of China, outside of the China to a third country, they must get the consent from the parents, the guardians. And also the third country, the law of the third country should protect, the protection in the third country should be less, should be at least equivalent compared with Chinese law protection to the minors, but it's only for the minors. And the third one is fragmented harmonization of substantive law. So there are harmonization efforts, especially in European Union and in US, and here US broadly means North America, including Mexico, because the US, Mexico, Canada free trade agreements. So there are two treaty blocks. They try to harmonize personal data protection, especially for the liability of the intermediaries. Okay, intermediary refers to Google, Facebook. They are all intermediaries. So how about China? So also last month, China concluded a protocol with Singapore, which is most recent Chinese treaty practice. China has a FTA, free trade agreement with Singapore, but quite a long time ago. So the protocol intends to upgrade it. And the protocol also included an e-commerce chapter. But if you look at that e-commerce chapter, it only provides inspirational, encouragement to some extent, endeavor to, inspirational provisions on consumer protection, on personal data protection, okay, etc. There is no affirmative obligations. So it's quite different from US and EU. So the last one is from Americanization to de-Americanization. So my argument is the current internet regulation originated in and operate under the protection of the US regulatory environment. Why? Because if you Google the top 10 internet company, six or seven are all US companies. So those companies, because they domiciled in United States, they are protected by US law. Why? The most typical is the judgment recognition enforcement. So you may be aware of, this is early in 2001, it's about the souvenir, the items that were auctioned on Yahoo website, but the items are related to the Nazism in World War II. So this is against French law, also because of the World War II. But the Yahoo is a US company. So the French court actually imposed an injunction, a large monetary fines on Yahoo. But this judgment actually is not recognizable, enforceable in the United States. So very similar is 2 years ago, a Canadian court, actually the Supreme Court in Canada, issued a judgment against Google regarding intellectual property protection. So the Google, just like Yahoo, went to the court in their dormitory, which is California. And the California court held that this judgment is not recognizable and enforceable. Okay. So this is the Americanization. So while there are de-Americanization, quickly there are three elements. The first one is EU, European Union, Europeanization, okay, general data protection. And the second is the Christchurch Accord, I think is very influential, especially in Australia, including Australia. And the last one is the Huawei ban. And the significance of the Huawei ban is to the doctrine of internet sovereignty. So Chinese government, including Russian government, have advocated the internet sovereignty for a very long time. But you see this doctrine is only supported, to a large extent is supported by government. There is no industry support. Here I mean Chinese industry support. But I would say after Huawei ban and Chinese internet companies, they probably will support the internet and sovereignty doctrine. So overall, the interaction from the four trends is, I think there are two dynamics. The first one is the four trends, they are consistent with each other. Why they are consistent? Because they are all centered on the state interest. Because the interest of the US is different from interest of the European Union. Why? For EU, they protect it as a human right. But for US, they try to encourage the development of the industry, very similar as China. So, they are quite consistent. But the second dynamic is, if you look into the individual trend, actually the three jurisdictions, they contradict with each other. So you probably are not convinced, and I have some relevant publications. Yeah, so just some questions. Yeah, just very preliminary research. Yeah, thank you.